So I'm going to be going over what makes a law valid, the debate surrounding this topic. There are largely two camps represented by the two photos I put up on the screen. One is the legal positivist camp, represented on the left by H.L.A. Hart. The other is the natural law camp, represented on the right by Thomas Aquinas. This is a fundamental question in the study of law and the philosophy of law. So if you're trying to get into the philosophy of law, this is something you're going to have to deal with. So just some general questions to have run through your mind as you're thinking about this question is, what is a law? This seems like a very basic, question. Most people would be like, oh, I know what a law is, but it's really at the root of this, at what you consider to be a law, at what seems to be a law when you really rationally look into these things. Second question is, what is a law's purpose? Does it have one? And we're not talking about a specific law here. We're talking about law in general, law at large. Does it have a purpose? Is it aimed at serving the common good? Is it aimed at social cohesion? Is it aimed at just getting people to do what you want? Does law in general have a purpose? If so, what is it? And lastly, is there a necessary connection between law and morality? By this I mean, do law and morality, does morality inform law? Does law need morality, or can it just exist completely immorally, amorally, whatever it is? These are three questions that are at root of this debate. So the legal positivist take, represented by H.L.A. Hart, is that there is no necessary connection. This position, this legal positivist position, was first really created by Bentham. It was expanded upon by Austin. And H.L.A. Hart is really one of the more prominent, complete theorists of legal positivism. This is that there is no necessary connection between law and morality. A law is simply what is commanded by an authoritative body and enforced. So this gets away from a lot of the stretched reasoning of some natural law theorists of like, is jaywalking really a necessary connection to morals? Or there's laws about what lights you put up in buildings. There's all these just purely minute laws. And are we really saying that those aren't laws, or we're trying to say that they have some type of moral connection? And this also avoids the problem of saying that bad laws just aren't laws, because that seems to be too far. It seems to be that, yes, they are laws, they are valid laws, they're just not good ones. Next, the natural law take, this is the most prominent take throughout the history of Western philosophy. Most people have been natural law theorists. Recently, it's become much more legal positivist. But yeah, natural law theory was really the number one for a while. This is that law does have a necessary connection with morality. It aims at the common good. It aims at social cohesion, and there is an objective way to do these laws. These laws are not created by man. They are found by man. And man has the special capability of reason. It doesn't have to be. It's largely a theistic kind of Christian picture that man has this special ability of reason endowed to him by God, and he can discover these laws and then implement them. And because of this, since a law is like the subjective thing you discover, aimed at social cohesion, aimed at the common good, an unjust law is no law at all. And to many people, especially many secular people, they'll say, well, no, there are a ton of bad laws, but there's still laws, it doesn't have to aim at the common good to be a law. But this natural law theory, this natural law take, even if you are secular, can be very helpful in dealing with a lot of past wrongs. So if you look at America, in the country I'm in, you see Jim Crow and just slavery, horrible law after horrible law for a good bit of the country's history, aimed at marginalizing and oppressing and harming one group. Now, it would be very useful to be able to say these were not valid laws. These were not laws. These were immoral laws. They were not aimed at common good. They were not discovered by man's reason. They were hateful. They were prejudiced. They were not laws. And still a positivist might maintain, well, they were laws. They were valid laws. We're not saying they're good laws, but they were laws. But then an even stronger pushback against that by the natural law theorist would be that of the Holocaust. Um, this was German law. They did this to people. They killed Jewish people. Whoever they deemed they wanted to kill, they would kill. And it seems to be that a pushback would be, hey, look, if this is a law, then the people who were committing it were just following their law. It was the authoritative body who told them what to do. It was the law. Now, legal positivists might say, hey, well, no, like we have this theory of obligation, and you can't just follow a law because it's a law. And that seems to be a fine pushback until you get into, well, now how do you hold these people accountable? And this is the whole Nuremberg problem. How do you hold people accountable for simply following the law inside their legal system, especially when you do not have a legal ground to stand on outside of that, if you're a legal positivist? So, this is an ongoing, never ending debate in the philosophy of law, whether you take the legal positivist side or the natural law side. I mean, I think many people would say legal positivist side seems more just rational. It seems like it's just true when you look at the world, but it's not very useful. A natural law theory of law could be much more useful in condemning things like Jim Crow, condemning things like the Holocaust, and then holding the perpetuators of it accountable. And it also really really pushes for the common good, which a lot of people would want to take up.